event, Evolving Legal Considerations During COVID-19, Ask an Association Attorney. I know that everyone is very familiar with Zoom these days, but just in case you need a refresher, I'm going to go over some logistics. At the bottom of your screen, you'll see a Q&A button and a chat button. Please use the Q&A for any questions for Jeff, and please use the chat to engage with your fellow attendees. We'll be recording this webcast, and the recording link will be available within 1 week on the Issue Roundup page on ASAE's website. So back in February, we first heard from our speaker, Jeff Tenenbaum, when associations were first examining their legal options with regard to event cancellations. Since that time, so much has happened as we've adapted our events and our associations to both work and meet in a virtual environment. As such, our legal concerns have expanded to include so much more than just event contracts, and now include everything from renegotiating building leases, mitigating risk once offices are reopened, virtual meeting codes of conduct, and virtual governance, to name just a few. Both before and certainly since opening his own practice just before the pandemic, Jeff has become a go-to legal resource for so many associations, especially as they navigate this new normal. Prior to opening his own firm, Jeff practiced law at Venable LLP in Washington, D.C. for 19 years. He was a partner and chaired its nonprofit practice for most of that time, served on the firm's board of directors for many years, and co-chaired their management review process. Jeff is author of the ASAE published book, Association Tax Compliance Guide, a true page-turner, and currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. Most importantly, though, Jeff started his career in the association community by serving as a legal section manager at ASAE. For today's presentation, I'll prompt Jeff's remarks with a series of topics based on discussion threads we've seen in Collaborate, and we'll also seek to answer questions that you pose in real time, so please feel free to pose questions in the Q&A box, and I'll attempt to aggregate them as we go along. So I'm going to kick us off with our first question. Jeff, you ready? As associations contemplate the eventual return to in-person meetings, what are the key liability considerations to protect both the association and its attendees? And should we require attendees to agree to a liability waiver?
There's a lot there. I will keep this brief. And as good afternoon, everyone. Good morning to those of you in the West Coast. We're going to try to cover a lot of ground today, but this is a program that, while Karen has a number of questions that she's going to pose to me that are based, like she said, in part on things that we've seen on ASAE Collaborate forums, but also based on what my colleague and I are seeing and hearing from our association clients every day in terms of questions. We want to hear from your questions today as well. So please start up right away. Particularly if you have kind of follow-up questions on these particular topics, please pose them in the Q&A box, and Karen will kind of pose those as follow-up questions to me. So in some ways, this question about in-person meetings might be a bit premature. For many associations, it's most definitely premature. We have a number of clients that don't even want to remotely contemplate an in-person meeting before, say, the middle of next year at the earliest. We've actually had some calls with clients this week that have meetings scheduled for February, March, April, and even May of next year that are already looking for ways to terminate those in-person meetings and those contracts. But at the same time, other associations, depending on where the meetings are being held, depending on the size, depending on the timing, and depending on the course of the coronavirus, are contemplating some return to potential in-person meetings. Some of them contemplating hybrid, kind of in-person and virtual meetings. Obviously, this has very significant contract and liability and financial consequences as well. But this question talks about from a liability perspective, and mainly from the perspective of if someone attends our in-person, I'm just going to call it meeting to refer to conferences, meetings, and other association events. If someone attends our meeting and claims that they contracted the coronavirus at our meeting, and that the reason they contracted it at our meeting is that we, the association, probably the venue like the hotel as well, were negligent in not providing proper health and safety measures, then theoretically, if an attendee could prove that they contracted the virus at your event, those are kind of the core elements of negligence liability, which is what we're really talking about here. Did the association have a duty to provide a safe environment for attendees? Did it fail to meet whatever the accepted standard of care is at the time? Was there causation? Did that failure to live up to that standard of care cause the person to contract the virus? And then there's the element of proving damages. Those are kind of the four core elements of negligence liability. And as a result of that, you don't need to go to go to law school and go through a first year torts class to learn that. But what you do need to know is the part that I referenced there in terms of the standard of care. That's what's really critical. So what is the standard of care that a reasonable association would be obligated to meet if it's going to hold an in-person meeting? Well, first of all, that standard of care is evolving every day. Just 2 weeks ago, there was a new guidance document put out by the Centers for Disease Control and Prevention, the CDC, referred something about guidance for large gatherings. And by the way, there's going to be an email that'll go out to everyone, I believe, later today or Monday or next week, with a link to a number of articles of mine and of ours on some of these topics. And the most recent article, which is about liability waivers for in-person meeting attendance, has a link to that CDC guidance. That CDC guidance is very important because while it's not binding, it's only guidance, nothing the CDC, for the most part, or nothing they have put out to date in this pandemic has been binding. It's all been advisory in nature, but it's still compelling, it's still relevant, and it most certainly helps to establish what the standard of care is for in-person gatherings. There's a lot in there. There's a lot of stuff in there. Some of it is going to apply to the association that's sponsoring the event. Some of it's going to apply to the meeting venue. I'd say, if I recall, probably more of it would apply to the meeting venue, to the hotel or convention center or other venue, than would to the association. But these are the things that you're going to need and want to do as many of them as possible, as cost efficiently as you can, in order to show that you met the standard of care. That's what you're going to need to do to help avoid liability if someone does in fact contract the virus and can prove that they contracted it at your meeting. Two kind of related points. One is, and you probably can gather this already, it's already become a real point of tension and contention between associations and hotels in particular as to who has responsibility for what, and especially who's going to pay for what. This stuff is not cheap. It's expensive, it's burdensome, and the hotels and some of our negotiations are already pushing back hard, not wanting to be contractually obligated to do and have to pay for all of these various things. But from the association's perspective, both to protect your attendees and your employees, frankly, as well as to mitigate liability risk, you want to be able to show that you did everything you possibly could to require the hotel to do as many of these things as possible, even if it's not in a formal addendum to the contract, even if it's just in an email exchange back and forth, where the hotel is, you give them a list of everything you expect them to do, and they write back and say, we agree to do the following things. That's very helpful in mitigating your liability risk, showing you were not negligent in how you put this event together. And of course, it'll go a long way toward helping protect the health and safety of your attendees. Finally, Karen, the last part of your question related to liability waivers. I'm getting this question virtually every day, sometimes multiple times a day. And I know it's a big discussion topic on a lot of the kind of meeting planner forums and online forums. Here's what I'd say about a liability waiver. Someone, basically you say to an attendee, as a condition of attending this event, you have to click and accept that you agree that this is a risky environment, you're knowingly assuming some risk, and if you contract the virus at our event, you agree not to hold us, or maybe the hotel as well, liable for any damages that result. It's a classic technique that associations have used for years. I've drafted hundreds of them over the years in connection with kind of more physically risky activities that sometimes occur at association conferences, like runs and bike rides and hikes and other things like that, even yoga retreats and other things like that. If you think you can get all or most of your attendees to agree to such a waiver, it's probably not a bad idea. It can't hurt. But what you should realize is that these liability waivers, they get tossed out by the courts all of the time for a variety of reasons. And while they may help you to a certain extent, they're not going to be a panacea. They're not going to enable you to avoid doing all of those other things I talked about to meet the standard of care. And so while they're helpful, they're definitely not the end-all be-all, and they should just be one tool in your kind of risk mitigation toolkit. So sorry for the long answer, but that was a lot of questions.
There's a couple of follow-up questions. So someone asked about staff at meetings, and can they claim workman's comp for being injured on the job? And how is what is our risk that we're assuming as organizations for our employees in this climate?
Okay, so here's the way you should think about this. And I was actually just prior to this working on a new article about kind of the top 10 questions that I'm getting in connection with association events and liability risks. And one of them is all about insurance, which is what we're talking about here. So I referred earlier to all those steps you're doing to keep your attendees safe. Well, those things also apply to your employees, right? And almost in an identical way. The same things that apply to help protect your attendees are going to help protect your employees. You arguably have some obligation to your employees that even go beyond what extends to your attendees. For instance, and I was thinking about this because I was reading the summary of the guidelines for Major League Baseball when they're going to start playing baseball again next month, and they have some very, very detailed guidelines about everything that the players can do and can't do, on the field, off the field, and mainly on the field and in practices and in games and whatnot. But the article I was reading in the Washington Post talked about the fact that what was noticeably absent is any real guidance for what players can do when they kind of in their off time. And that's, of course, a real risk, because if a player is going off socializing, going to bars, not wearing masks, doing other things, and then comes back and infects their teammates, that creates, a very significant risk. And think about it, the same thing can apply for your own employees. Now, it's going to be very difficult to kind of regulate, your overall attendees' behavior at conferences, although we're probably talking a bit about codes of conduct. But certainly for your employees, I think you have a more heightened obligation to do what you can to regulate their off-time behavior, at least in connection with conferences. When they're off site at a multi-day conference or something like that. But the question really related to insurance. And so you do all these things to show you're not negligent, to try to protect everyone, but you still get hit with a suit, right? You can never stop someone from suing you or filing a claim, whatever the form might be, in the courts, administrative form or whatnot. On the attendee side, what you have to help protect you is called commercial general liability insurance, what a lot of people call slip and fall insurance. Something that virtually every association has, very common, very standardized. All of the major policies are all the same. They're based on the same standard form. And at least for now, none of them include any exclusions for communicable diseases. So if you got hit with a suit from an attendee claiming that you were negligent and as a result they contracted the coronavirus at your event, you should be able to file a claim with your commercial general liability insurance carrier, and there should be coverage, at least the duty to defend the lawsuit. Whether they would ultimately pay for any judgments or settlements against you is an open question. They would likely push back hard on the causation element, saying it's almost impossible to prove that someone contracted the virus at your event, so therefore you were not the cause, but they would still have a duty to defend. Similarly, with respect to employees, that's sort of the same circumstance that evolved, and the employee files a claim. That's generally going to be covered under workers' comp because it's an employment-related event. And similarly, workers' comp insurance policies generally do not include, or at least for now, any exclusions for communicable diseases. So yes, as essentially an insurance safety net, your workers' comp should provide a defense for those sorts of claims. There are no communicable disease exclusions to date in workers' comp policies. And again, that same caveat about whether they would pay for ultimate claims is yet to be seen. But workers' comp is basically a mechanism where employee claims for kind of personal injury and property damage, that's where they kind of have to be funneled in order to be dealt with in most states.
Jeff, there are a few questions about standard of care and the definition of standard of care Who defines it? Is it the venue? Is it the jurisdiction where the event is taking place? What are those guidelines?
So first off, it's something that we learned about in first year law school in torts class, where they teach about negligence liability and the elements, and one of them is the standard of care. And one of the things that you learn from those cases that we had to read and analyze is that the standard of care can come from lots of different places. You first look to applicable law, right? Is, like, for instance, right now, some states and a lot of cities and counties are issuing very particular guidance for the conduct of larger gatherings. In fact, I was just reading something this morning about some new guidance that was put out, I think yesterday or today, from Prince George's County, Maryland, in the DC area. There's a big Gaylord property there. And that guidance, which I believe applies to gatherings up to 50 people, has some very specific social distancing requirements and whatnot. That is part of the standard of care. So if you're holding an event at the Gaylord National Harbor that fits within the number of people, you're obligated to follow those guidelines that the county has put out, in addition to whatever applicable guidelines might be in place from the state of Maryland. That's part of what forms the standard of care. What the CDC has put out for large gatherings is another component of what forms the standard of care. And not, I would say ironically, it's not really ironic, associations in different industries often put together standards that help to form the standard of care. In fact, I've seen many times over the years that like standard setting that's done by associations is often used in litigation about, in tort suits, saying that this was the established standard of care, for doctors, for manufacturers of a particular product or whatever else. And, you failed to follow these voluntary standards put out by associations. If the hotel has certain guidance, for what its groups that come in to do events at the hotel have to follow, that's part of the standard of care. So all of those things are relevant, and they all help to form the standard of care. It will evolve over time, right? The standard of care right now, when there's no available vaccine, is going to be very different from maybe the first 3 or 4 months when, vaccine, or probably multiple ones, start to come on the market, but before they're widely available and widely administered. So it's kind of a rolling thing that you always have to keep an eye on. Obviously, the more that you can do, the more of these things you can follow, the better off you're going to be in reducing your liability risk. And one other kind of corollary point to this that I forgot to mention earlier, and it was an idea I got from a client earlier this week, is that if you were going to go the waiver route for your attendees, it's not a bad idea to, in addition to the waiver where they're releasing you from liability and voluntarily assuming risk, to also have them affirm that they will comply with whatever rules that you issue for your attendees. So whether it's mask wearing, social distancing, not going off site, whatever the various rules are, particularly the first two, you want to get them to affirmatively agree as part of that they agree they will honor and follow those kind of dictates. I think it's a very, very good idea.
Let's shift gears a little bit to our to the second aspect of events, which is mitigating cancellation and attrition penalties. And what are the strategies that we should be employing, and how has it changed from 2 to 3 months ago in terms of event cancellation? And just adding on to that, a couple of questions have come in with having to do with organizations having issues canceling events in a few months. Like, what is the window that that people should be looking at for when they can cancel their events?
Okay, first off, this has been my life for the last 3 months, is counseling associations through these meeting cancellation issues. I've worked easily with over 150 different primarily national associations on all of these issues, and for many of them now on multiple different conferences and events. This also, and I've also done probably 20 plus different webinars on this topic as well. So this is a lot to compress into a 5-minute or so answer. And again, that's one of the articles that Karen will be sending out to everyone, which is a lot of very detailed practical guidance on these issues. But even that article, which I wrote maybe, I think my colleague and I wrote together 6 weeks ago or something like that, it's probably started this week or maybe last week, that some of the calls we're having with clients where we kind of talk through these issues and talk through various strategies and options and pros and cons of different options and try to come up with a game plan. That has evolved, particularly in the last couple of weeks, I think for a variety of reasons. So in the beginning, and this is a really compressed version of this, happy to talk offline with anyone who wants to discuss these issues in more detail. But first off, in the last few months, the game, and I hate to call it a game, but it really is a game. It's a dance between the meeting venues like hotels and convention centers and the associations. And it's this kind of back and forth legal dance that's been going on to try to figure out a way for the association to be able to cancel, which is pretty much what's happened across the board for the last few months, and for pretty much most meetings, at least through the summer, to be able to cancel without penalty, being able to rely on the force majeure clause in your meeting contracts. That's the clause that says if something happens beyond our control and it has some effect on our ability to perform under the agreement, then we can be excused without penalty. So that's kind of the desired end game, so that you don't have to pay what are otherwise very typically significant cancellation penalties. Most of those clauses say that that unforeseen event makes it illegal or impossible for you to perform under the contract. Some also say inadvisable or commercially impractical, which is a much broader, more flexible, kind of lower standard to meet. But I'd say 85% of the hundreds of clauses we've reviewed probably refer to illegal or impossible. And pretty much most of the venues have taken the position that the only thing that makes it illegal or impossible for you to perform is if there is a directly applicable governmental ban. And we're not talking federal because there are no federal bans, but state or local bans on your ability to hold a meeting of your size on those dates at our venue. So the geography matters, the size of the meeting matters, because these bans on large gatherings vary by size, and they will increasingly that'll become even more important as more gatherings start to be allowed, and then the location, obviously, and what sort of applicable state or local guidelines or bans on large gatherings are going to apply. In the beginning, for meetings that were scheduled, we started doing this in late February, early March, for meetings that were scheduled in April, May, June, fairly easy to get away with a successful force majeure termination. And generally speaking, here's the rub here is that it's all about timing. The closer you can get to your meeting dates. So say there's a ban, say your meeting is 2 months away, and there's a ban on any gatherings of your size in place now, but the meeting won't occur for 2 months. You can't obviously wait until the last minute, although we've actually had some hotels and hotel attorneys actually say that you have to wait until the last minute to do that, which is absolutely insanity. In our experience, though, if you can get within this is what it's been like for the last few months, if you can get within a 60-day window of the beginning of the meeting, and there's a ban in place now 60 days out, we've had probably a 98% success rate I'd say almost 100% cancellation, force majeure termination with the hotels or convention centers accepting a penalty-free cancellation within that window. I'd say if we, what I've told clients is that the maximum I'd like to see is 90 days out. And because there's so many other pressures on associations to cancel the in-person meeting, you're not just driven by the legal considerations. And so I get that. I've heard it hundreds and hundreds of times. And I'd say for the 90-day out cancellations where there were bans in place and the meeting was going to occur 90 days later, we've had probably a 95% success rate. But that is starting to change. It's starting to change as states and cities and counties start to open up their economies. It's starting to change as, frankly, hotels and convention centers seem to be taking a harder line on force majeure termination. And we've seen some take really hard lines throughout this, but by and large, most have been fairly accommodating. I'm starting to sense that it's tightening up. And there now a lot of probably all of the big hotel chains are starting to work on plans for social distancing, for being able to actually hold in-person meetings and try to honor their obligations under the contracts. And as a result, this is becoming more difficult, even for a meeting that's, say, in November of this year, and we're in late June. To do a force majeure termination now, it's a tough thing to do, to make an argument that there's a fairly high degree of reasonable certainty that that ban that's in place today is going to be in place in in mid-November. That's just a hard thing to do, and the hotels push back. They say you don't have a crystal ball, you don't know that. So to say that it's going to be illegal or impossible for you to hold your meeting in our city in mid-November, it's just impossible for you to say. Therefore, we reject force majeure termination, and therefore here's your bill for all the cancellation penalties. So the real and really the only strategy until now, if it was too soon to do a force majeure termination, was to negotiate with the property, generally to try to book a future meeting, generally kind of at the same size and scope, a future meeting in exchange for the hotel waiving or at least reducing the cancellation penalties. And we've had a ton of success with clients in doing that in the last few months. We're seeing, though, that become more difficult. And a lot of the hotels, we've had a lot of success where they just said, okay, you book a meeting 2 years from now, 3 years from now, the same size, and we'll waive the cancellation penalties, or we'll just apply them to the future event. Sometimes they're making associations pay some of that in a deposit, but still not having to really effectively pay any cancellation penalties. We're starting to see that tighten up more, where a lot of the hotels are saying, okay, well, if you rebook, we'll apply 50% of the cancellation penalties to that meeting, but the other 50% you have to pay as a cancellation penalty. It's becoming more difficult. So kind of the new tool in our toolbox, and I hate to look at it this way, but these are tough negotiations, and the hotels and the convention centers are doing the same thing on their side. Kind of the new tool has to do with the discussions about in-person meetings, okay? So what you're going to be forced to increasingly do, again, this is presuming that right now what we're seeing is, this resurgence of the virus, and we're seeing a number of states and cities kind of reversing their reopening plans. So this is all subject to what happens here, but presuming, hopefully, this virus gets, under better control going forward and reopening plans continue, and larger gatherings, it might start with gatherings the size of a board meeting, and going to larger meetings as they start to be permitted under the laws and rules of certain states and cities and counties. What you're going to need to do is work with the venue to say, okay, this is a meeting contracted for 300 people. Based on the current social distancing mandates and guidelines, here's what we calculate the kind of space that we would need in the common space in the meeting areas in order to make this work. Show us how you can do this. Show us how you can provide us a space. We're not going to pay you extra for doubling, the space if you even have it. But show us, and here's a list of everything we expect you to do to be able to social distance, to be able to keep it safe and healthy for our attendees. Show us how you can do all of these things. If a hotel in a number of key areas, including on the space and social distancing requirements, is absolutely unable to do it and unable to show you that they can do it, what that gives you is an argument for what's called anticipatory breach of contract. So this is different from force majeure. It might seem similar, but it's different. It really has nothing to do with the force majeure clause of the contract. What it's saying is that if the hotel cannot perform its contractual obligations, with these new exterior, laws, rules, guidance on social distancing and whatnot that are being imposed on the meeting, if it's not able to perform its obligations in a material way, then it has anticipatorily breached the contract. And if that's the case, it would give your association an opportunity to get out of the contract without penalty. It's kind of classic contract law, another class you take in first year law school. Who knew all this would be so relevant in this pandemic? But it's an approach that kind of it's two sides of the same coin. One is that if you end up having an in-person meeting, maybe a hybrid in-person virtual, like a lot of associations are contemplating, it enables you to have a game plan to know that you can do it safely, relatively safely. And if the hotel or venue is not able to accommodate you, it may give you an opportunity to get out of the contract. So that's the biggest. Those are the biggest changes that we've seen in that whole world.
So Jeff, a couple of quick follow-up questions, and then I think we want to move on from events because we could spend hours just talking about events. One has to do with if there's anything that we can do when our attendees, and maybe it's based on the industry that they're in or not, that they themselves are now banned from travel. So we know up front that in the current situation, 25% of our attendees who would have come are now being prohibited by their employers from coming to the event. And then there was one other question, and now I'm obviously not finding it.
By the way, I saw someone just asked, what was that term I just used? It's called anticipatory breach of contract. Yeah, so that question is one I get just about every day and have for the last few months. fact, yesterday we had a client that said their conference is in May of next year, and in the association in the healthcare space, as a lot of our clients are, but we also have a lot of associations in the higher ed space. Those two sectors have been really hit hard by travel bans and bans on professional education expenses. And so for meetings that were going to occur, scheduled to occur this year, that has been kind of another tool in the toolbox for force majeure termination, with the association taking the position that, look, if we can show through surveys or whatnot that the vast majority of our otherwise would-be attendees are not able to attend because they are prohibited from travel by their employers or their institutions, then it's impossible for us to hold the meeting. Especially if your force majeure clause has the words inadvisable or commercially impractical. I think that argument is even more compelling. You could still make the argument about impossibility, but I think it's more compelling if you have the more flexible language. That being said, I have to tell you that most hotels and convention centers have scoffed at that position. They have not given it any real credence. They say it's all about governmental bans on large gatherings, and that's all it's about. But that being said, in every termination notice that we have drafted for clients where that is a relevant issue and argument, we have utilized that. And I suspect if any of these cases ever get litigated or arbitrated, that would be relevant in the analysis. But don't lead with that. That's never going to be your strongest argument. The governmental bans are one thing. Right now, and we talked about mainly the bans on large gatherings have been the primary focus and stay-at-home orders. But now we're also seeing some of these state travel bans. Where I think New York either has announced or is contemplating announcing. New York and New Jersey and Connecticut, I think, announced yesterday, mandatory 14-day self-quarantine requirements for U.S. Folks traveling from other hotspots like Florida into New York. This is all relevant, but again, it's all about the timing issue, right? How can we? That may be the case today. How do we know that's going to be the case 3 months from now or 6 months from now? And back to that example I told you of, the client in May. I told them, look, unfortunately, you don't have any way of knowing that your likely attendees are going to be subject to travel bans next May, and there's just no way the hotel is going to give that any credence. Similarly, force majeure termination, it's just way too far out to even contemplate that right now. And so, frankly, the only two strategies left that I can come up with, and I've talked to other kind of attorneys in this space who do this kind of work, and we've kind of compared notes, and there's no secret or magic other strategies out there, but the only two other ones are to try to renegotiate with a property for a new meeting or conference in exchange for reduction or elimination of cancellation penalties. And by the way, sometimes you have to sweeten the pot. I've suggested this to a number of clients, and it's worked, where if you're willing to sweeten the pot by, say, increasing your food and beverage minimum spend for the other future event, that's been a compelling deal point in helping to make these negotiations work. Or the other approach of trying to plan out what the event would look like, an in-person event with proper social distancing, and seeing if the hotel can make that work.
So shifting gears from events, let's talk about returning to our offices and the quagmire that is that. And so what key strategies do you think we should be putting in place to protect the association and our employees and the liability considerations when we return to our offices?
Great question. Also subject of a recent article of mine. Even though it seems like I actually wrote that article about a month ago, but it seems like it's almost still premature. And not completely. We actually have some clients that have started to go back to their offices, but on a very limited scale and completely voluntarily. I'd say from my vantage point, most associations are not at that point yet. Most associations seem to be waiting until at least through Labor Day, to talk about any serious potential return to offices. But it will happen at some point. And when it does happen, or even before it happens, you have to plan for it. I have one client in particular. It's a large nonprofit, not an association, but large nonprofit with various offices across the country. And they recognize that they already have to start planning, because if you're going to do a lot of the things that are going to be necessary to help protect your employees, it's going to take some time, some money, and you can't just do it overnight. So the first thing you look to, it's the same basic analysis that we're talking about for holding in-person meetings. What is the standard of care that you're obligated to follow to bring people back to your in-person offices? And have you largely met that standard of care? And the difference here is that there is a standard of care that has already been established effectively by OSHA, the Occupational Safety and Health Administration. It's a federal agency that has actually issued some really detailed guidance about kind of the return to offices in the era of COVID-19. My article that Karen will send you has a link to that guidance. Very important to follow that because it's, I can't remember if all of the aspects are mandatory or some are advisory, but regardless, I mean, obviously if it's mandatory, you have to follow it, but even the things that are advisory, which I believe some of it is, it still effectively creates a standard of care for liability purposes. And so you need and want to follow as many of those things as you can possibly do to be cost effective. You know, they involve a lot of the things that you would expect, you know, requiring masks, having people socially distance, you know, not allowing people to gather in common areas, or if you do, have very strict requirements about distancing. Obviously, very regular, you know, frequent and effective sanitation and hand sanitizers everywhere, and all of those sorts of things. But also things like, you know, having people staggered, you know, when they arrive in the offices. You know, I've seen a lot of news stories about elevator usage. You know, for those of you that are in buildings where there's elevators, the less people you have coming in and at the same time, the easier it is to be able to social distance in all those types of common areas. Not having everyone come in 5 days a week, but again, you know, staggering when people come in. Making it, some of this is from the OSHA guidance, some of this is just from other best practices that I've read about. You know, things like, and what I put into my article too, things like making the return voluntary, at least for a period of time, and especially for people who just don't feel safe. Certainly requiring people that have any ill health effects, requiring them to stay home and not come into the office. You know, requiring them to self-quarantine for 14 days if they, you know, once they recover, or if they contract the virus. You know, all of those sorts of things are going to be important to do, and you know, they're not going to be easy things to do. So, you know, one of the big things that we've seen in recent years is so many associations have gone to these open office environments. I'd say I'm in DC, and I'd say the majority of the offices that I've been to of my clients, which is a lot of them in DC, the majority have those office floor plans with all these cubicles and whatnot. Probably the worst thing from a social distancing requirement. So how you make that work, you know, do you space it out every other cubicle? Do you put, you know, plexiglass partitions in between cubicles? These are all things that associations and other employers are dealing with. The ventilation systems are a big issue and question, particularly in, say, older buildings that don't have as effective ventilation systems, trying to get air in from the outside. And I am by no means an expert in any of these things, but these are the kinds of things that you need to think about and look at the OSHA guidance, but look at other best practices that are out there. There's some associations that have put out some best practices for this stuff. Take a look at all that and do as many of those things as possible. And if you do all of those things, if someone does in fact contract the virus in your office or traveling, you know, so all this, you know, these same rules are going to apply when someone is going to meetings, whether it's travel in the same city, whatever, during work time, you know, or on behalf of your employer, your association. These things, you're gonna have to put guidance in place for that as well. But if you can show that you were not negligent in how you brought people back to work and what you required them to do and what you did not require them to do, all of those things, it's gonna go a long way to showing that you were not negligent as an employer. And then of course, like I said earlier, you do have that workers' comp as kind of a safety net. You know, I've gotten the same question about waivers. Can we have our employees sign a waiver? In the employment context, it's virtually useless to do that, because courts say that unless you're going to offer some additional consideration for someone signing the waiver, if you require an existing employee to sign some sort of a waiver like that, it's not going to be valid. It's going to be tossed out by the courts if someone ever challenged.
There are a few follow-up questions about what if your employees want to work from home permanently? And that's not been something that you've had before. I don't know that you'll have a recommendation writ large for something like that. But also, how, if you've been really successful in working remotely, the case for coming back or not coming back, um, renegotiating leases, things of that nature. What are some of the things that you're seeing in the clients that you're working with?
All of the above. Seen all of that. I have some clients that have decided they are going 100% virtual. They still are stuck with some office leases, and they're going to have to just try to negotiate their way out of it. Probably take some sort of a financial hit, basically paying a penalty to be able to get out of it early if they can, or just continue to maintain the office space, but for a reduced number of employees. We have some that I've had some CEOs tell me, look, I know my employees love this, but they're not nearly as productive as they were when they're in the office, right? And that's not across the board, and I think for most of us, we'd say we're equally productive, if not more so, at home with less distractions and less commuting time and everything else. But I have heard this. I'm not making this up. That some CEOs and other managers have said that their people are not as productive working from home, and they want them to be back in an in-person office environment, at least for part of the time. So every association is different. Whether you decide you want to allow all or some of your folks to work, remotely, virtually on kind of a permanent basis or not, there's so many considerations that go into that, and that's not for me to weigh in on. From a legal perspective, though, you do have some considerations there in terms of basic employment law considerations that we've dealt with for years, from kind of the advent of the possibility of telework, probably, 30 years ago, 25 years ago. From that point, we've always had these issues of, how can you do this in a fair and balanced way where you're not discriminating against people, allowing some to work from home and some not? Are you unfairly, illegally discriminating against people on the basis of some protected characteristics? So you have to have some objective policy that's equally applied across the board and applied on a consistent and objective basis. There's no question you have to do that. What that policy is, can vary. Like, for instance, in the past, a lot of associations had policy, their telecommuting policy, which is what it used to be called, and it still is in some associations, would say to even be eligible to telecommute 2 days a week, you have to be an exempt employee, not a non-exempt employee, for a lot of issues related to the Fair Labor Standards Act, which is beyond the scope of this program. But, that's, I think, changed already, right? Because you have so many non-exempt employees who are working remotely, and it's working just fine. And employers have instituted procedures to say, you can't work more than 8 hours a day without express prior advance permission, and all the other things you need to do to regulate time. You have to take mandated breaks and other things like that. And a lot of employers have found ways to do that in the virtual environment that they never perhaps thought possible in the past. But whatever the rules are, they have to be applied kind of objectively and fairly and on a consistent basis. That's going to be absolutely critical.
Got it. We're going to talk about events, but virtual events now. So many of us, as evidenced by today, for example, have moved to offering many virtual events and have changed our in-person conferences to virtual conferences. And can you talk a little bit about those kinds of contracts and the unique facets of virtual event contracts?
So, like with any other association event, be it an in-person conference or a virtual conference or a virtual webinar, or whatever the case is, generally the bigger the event, the more complex, the number of hours, the number of days involved, the more contracts are going to be involved. A typical association annual conference has probably dozens of different contracts involved, right? You got your big ones with the convention center, maybe multiple hotels. You have your big vendors, AV, other things like that, transportation. You have, contracts with particular outside venues where you're holding special events. You have contracts with speakers, you have contracts with exhibitors, you have contracts with sponsors. You have so many different contracts involved. So you got to think about it broadly. We're not just talking about, the big event contracts. It's all of these. And frankly, in connection with this pandemic, we've analyzed hundreds and hundreds of these various contracts to figure out how the association can get out of it. And one of the things I think a lot of associations have learned from this is the importance of tying these together. For instance, in your exhibitor or your sponsor contracts, having an ability to get out without penalty if the conference itself gets canceled or other things like that. A lot of these same principles apply to virtual contracts. And frankly, these two are linked because if you were going to do an in-person event, an in-person conference, and you had all of those different contracts that I mentioned. So while the hotel and convention center contracts and probably the AV contract and the transportation company contract, those you're going to dispose of, deal with however you can out, force majeure, pay penalties, whatever. But some of those other ones are effectively transferable, to the virtual contract. And associations have been dealing with this and struggling with it, frankly, because you can do virtual trade shows. You can have sponsors online at virtual conferences, but it's a very different construct, right? And the exhibitors, the sponsors, whoever else might not feel that it's worth the same dollar value. I'm sure ASAE is dealing with this right now in connection with the transition of its annual meeting, to a virtual conference. So a lot of these things have to be renegotiated. Same thing with speakers and everything else. So what is your ability to get out of your old contracts and enter into new ones or amend them? What's the willingness of the other side, to amend it? Are they going to accept lesser payment? All of these things are really difficult, and you have these kind of transition elements from the in-person to the virtual. And these are not easy things to deal with. On the virtual side itself, what are some of the things that are unique, to a virtual conference? Well, one of them is that, unlike the in-person conferences, these are very tech-heavy, contracts, or events, I should say. And so the technology that's involved is absolutely critical to making these all work. And so just like any other, we deal with hundreds and hundreds of, tech related kind of vendor contracts for associations every year. And all of the same issues that we deal with there, we're going to deal with here too. Things like performance standards and what happens if they don't meet certain performance standards, and what's your ability to terminate prior if you're not happy with the way things are going. What sort of penalties are there? Do you have exclusivity clauses? Say you had a contract, which most associations do, with another company that you were using for your regular webinars. Does that contract have some sort of an exclusivity clause that requires you to go to them first, to give them the first right of refusal at hosting your virtual annual meeting? Or can you go elsewhere? It all depends on how a lot of these contracts do have such a clause, but it depends how it's written. We've helped advise some associations on that. And also in other contexts too, like certification programs, where there was in-person certification testing and now you're going to a virtual certification testing. Does the contract with the party for the in-person testing have some exclusivity clause that applies in the virtual world? These are some of the kind of things that you have to look at. Remind me, Karen, I do want to come back and talk about some kind of issues with speakers and copyright issues.
Yeah.
We'll deal with that separately.
Right. Well, that was going to be my next question. So we can go right there, which is both in terms of if you cancel your in-person conference or meeting, what flexibility are you seeing in speaker contracts? And then how does that transfer to a virtual environment?
Okay. So first off, there's not a lot of commonality that I've seen among the speaker contracts. They're all very different. Some have some force majeure provisions, some don't. Your ideal situation is you have a force majeure provision that enables you to terminate the speaker contract without penalty. Or it has something that says if the in-person conference gets canceled, then there's no obligation to perform under the speaker contract, right? That's the ideal situation. Then you're out, you're clean. And if you decide you want to negotiate a new contract with that speaker for your virtual conference, you can, but probably at a lesser dollar amount, obviously no travel expenses, all the other sorts of things that go into it. If you don't have that ability to get out, then it's all about negotiation and transitioning it to the virtual. Hopefully, maybe you're going to have to pay the same amount. Hopefully you're not. I think that generally across the board, what we're seeing is that most virtual conferences aren't bringing in nearly the same revenue, and you can't charge nearly the same amount as an in-person conference. And so thus, on the expense side, you want to make sure that you're not, that your expenses are a lot lower as well. So all of that is really important on those speaker contracts. We did have a question that someone had submitted in advance of this program, and it's an issue that I've been dealing with a lot too, and that is, I think more related to your volunteer speakers, which frankly for most associations, that's the bread and butter of most of their speakers, right? You have your big high profile paid speakers, which is kind of what I was just talking about. But the vast majority of your speakers are your members and other volunteers who don't get paid for doing this. And that's great. And, I'm involved in some of this. I'll be speaking at the ASAE virtual meeting and doing the American Association of Medical Society Executives annual virtual meeting and other things like that. Those groups, including ASAE, they have speakers like me and all the others sign a form. And actually, I love the ASAE form because I actually drafted the original version of it years ago for ASAE. It's very well done. And that form has a few things in it. It has, representations and warranties saying whatever I'm going to speak about, it doesn't infringe anyone else's copyrights. It doesn't defame anyone. It doesn't violate any laws. I'm not going to use it as a stage for self-promotion or other advertising or other things like that. And then it importantly has a provision that says that I'm providing a copyright license to my speech and my materials, PowerPoint presentation, any handout materials, other things. I'm giving a broad license to ASAE to use that material in any way that they want, not just at the conference, but in the future in any other way. This has been a best practice for associations to utilize for years. It's a very simple, easy thing to do, so critically important to do. And if you fail to do it, it can cause so many problems down the road. Now, if it's a very broad, kind of well-worded copyright license like that, then it's probably going to apply almost in the same way to an in-person meeting versus a virtual meeting. But what we've seen is that a lot of these are not written as broadly as they could be or should be. And they're really written for that in-person conference and not for the virtual conference. So what you're going to want to do is look at your speaker forms, your speaker agreements, whatever you call it, and it should be an agreement because you want to make it binding, to make sure that it applies in the virtual world in the same way that would in the physical in-person world. And it's a good opportunity, frankly, to look at it and make sure it's doing all the things, that it has the appropriate representations and warranties I talked about, that it has the broad copyright license. You want it to be a non-exclusive, but unlimited use, worldwide, royalty-free, license to use that material in any way that you want in the future, in that form and anywhere else. So it's a good opportunity to perhaps, revise and improve on your speaker form. And one other thing that's related to that involves copyright. Because, spoken words like that, written words, written materials, PowerPoint presentations are all subject to the copyright laws. And you want that kind of license, which is permission to use. And by the way, a license does nothing to the ownership of the materials by the speaker. And you want to generally make it clear that you're not asking them to assign ownership to you. It's not an assignment, it's just a license. So it doesn't at all affect their ownership rights. And if it's a non-exclusive license, it doesn't affect their ability to use it or license the material to anyone else. But another kind of companion point that a lot of folks get confused about is the release. So you have copyright law, but then you have something called the right of privacy. The right of privacy is a state-based kind of common law principle that involves, there's the right of privacy and the right of publicity. The right of publicity applies to famous people. The right of privacy applies to the rest of us. And the right of privacy is different and distinct from copyright. So when you see in that form, you give us the right to record the presentation, video, audio, whatever the case may be, and use it in any way we want in the future, and to use your biographical information. This stuff relates to the right of privacy, not to copyright. So actually, if you think about it, like when actually ASAE is recording this webinar, and the recorder, whoever is recording something, that's the entity that owns the copyright to it. Believe it or not, that's the way it works. The photographer, the videographer, they're the ones that owns the copyright. If for associations, if you hire a videographer to come film things at your event, you want to make sure in the contract that they are assigning the copyright over to you guys. That's from a copyright law perspective. But from a right of privacy perspective, I have certain rights as a speaker, which is why it's always a best practice for, if you as an association are going to record people, that you ask for their consent to be able to record you, to use your biographical information, and to do whatever you want with it in the future. It's kind of like a combination. You want to cover yourself from the copyright perspective and from the right of privacy perspective. Very important.
So there's been a flurry of people asking us to now send ASE's speaker agreement out. So we will do that as part of the documents that we send. Note that it is, a work in progress, because as we're all transitioning from in-person meetings to virtual meetings, we're learning more about what we should be putting in these agreements and what we shouldn't. And speaking of learning about these things, something that we have just started at ASE working on is a code of conduct for virtual conferences for attendees. Jeff, can you speak on this at all? I know I'm throwing this as a curveball.
It's right here, the ASE Virtual Meeting Code of Conduct. I printed it.
You were prepared for the question that I wasn't planning to ask. That's awesome.
I was damn impressed with it. I thought it's pretty good. And frankly, I like it in that it's brief. It actually fits like on one page, 1.5 by 11 page. So look, codes of conduct for in-person meetings, this has been a really hot issue. I'm involved in a lot of, as you know, Karen, the legal programming that ASE does, from the law symposia and things like that. And, that's been a hot topic at that kind of programming for the last several years. It's been a hot topic in the articles and other things that we write from the Legal Advisory Council and things like that. And that's because, frankly, there's been a lot of bad conduct that has occurred at a lot of association meetings. I deal with this stuff all of the time, unfortunately, advising clients on various complaints, some harassment related, some other, that derive from in-person conferences. I have to say that the vast majority of the kind of the bad conduct at issue, the complained about conduct at issue, is alcohol related. It often, I'd say 90% of it is, bad conduct that occurs when alcohol is involved and people's judgment is impaired. Obviously, with a virtual meeting, you're not going to have those same issues. At least
maybe you are.
I don't know. I actually just reviewed this liability waiver for a virtual stair climb. And when I first saw the email from the client, I thought, wait, it's virtual, right? How can there be any physical harm? But I guess you're actually, following something online, and then you're doing this, stair climb. There is actually physical conduct involved. And so it was kind of a release, a waiver and liability release it was a charity, to the charitable organization. But anyway, bottom line is, for virtual meetings, the type of potentially offending conduct is going to be different, right? But there is a lot of the complaints that we deal with are also involve online activity, particularly forums, online forums like ASE has and most associations have. Harassment, intimidation, discrimination, all of these sorts of things. We deal with this all of the time. For as long as I remember, even I think when I worked back at ASE, when I was going to law school at night, I worked on some model, back then it was called a listserv, kind of terms and conditions, for kind of participation, which, ASE still has some version of those that they utilize for their forums, that when you first sign up, you have to click and accept that you agree to follow those things. Essentially, the way I think of it from an attorney's perspective is that your virtual code of conduct is going to be kind of similar to what you have for your forums. And in fact, if you look at ASE's, it's pretty similar. It's actually briefer than I think the rules that apply to the forum. But in some ways, if you already have good rules for your online forums, that's where you probably want to start to kind of adapt it to your virtual conference. So this thing talks about unacceptable behavior, harassment, intimidation, discrimination, verbal abuse of any attendee, speaker, etc., disruption of presentations during sessions. Presentations, posting, or messages should not contain promotional materials, job offers. Participants should not take or copy screenshots of any Q&A or chat room activity that takes place in the virtual space. So some of that is very specific, to virtual conferences, but it's a lot of the same things. It could probably, I know this is a work in progress, it could probably have some of the other things that I often put into those online forum terms and conditions, things about, no defamatory comments, no posting of anything that infringes anyone's copyrights or trademarks, no invasion of anyone's privacy rights, no discussion of anything that could violate the antitrust laws. Some of these other things that, frankly, because they're, at least what I've seen, a good virtual conference meeting is going to have a fair degree of interaction amongst the attendees. So all of the things that could occur on a forum could also occur at the conference. So, just suggestion, we might want to, expand this thing a little bit, but it's a good start. And it is very important to have one of these things. And frankly, where it becomes real, well, it serves two purposes. And you can say this about a lot of different types of policies, from codes of ethics to other things. It's prophylactic in that it helps to protect the association from a liability perspective. If someone does something, some person harasses another one, and that person, threatens to file a lawsuit that, they were defamed or they were emotionally abused or whatever the case might be, the fact that you have a policy in place that prohibits such conduct can go a long way toward protecting the association from being held liable, right? The individual member or whoever, the offending conduct, they may be held liable, but we want to make sure that the association itself doesn't get held liable. So having a policy against it can be helpful. And of course, enforcing the policy as soon as something comes to your attention, taking some prompt corrective action is also very important to helping mitigate your liability risk. But then it's also important when you want to take some disciplinary action. We see this a lot. It's a lot easier to suspend someone from future attendance, or we've even had some where someone gets kicked out of the association as a member for some really, really bad repeat offending conduct, things like that, or ineligible to run for office or other things like that. You want to be able to point to rules and codes that prohibit this conduct and that the person repeatedly violated them.
I do want to take a minute to mention to folks that we did list this as going until 3:15. So I know that some people are starting to write sort of concluding comments in the chat and the Q&A, and let you know that we're not quite done yet. More to come. So we're going to switch gears one more time and talk a little bit about governance and things like voting, and how have you seen governance processes moving virtually?
I know you're going to be shocked to hear this, but I wrote an article on that too. That's what I do during the pandemic. I write articles and give webinars. I wrote an article all about association governance challenges during the pandemic. I would strongly encourage everyone to take a look at that article, for two reasons. A, because it talks about far more nuance than I'm going to be able to get into in a few minutes here. But B, it's like a lot of these things, these are good opportunities to look at your governance policies, your bylaws, your policies, procedures overall to try to make improvements. And maybe you're making some changes, fixes because of the pandemic to be more flexible and allowing, membership voting or membership meetings virtually, things like that. But it's a good opportunity to review them perhaps more broadly and try to make improvements, try to comport with best practices, things like that. But in the governance area, one of the biggest effects of the pandemic has been the inability to hold in-person membership meetings, perhaps in-person board meetings, well, certainly in-person board meetings as well, but in-person membership meetings in particular, because in the past, so many associations where members have certain voting rights, like the ability to elect officers and directors. In many instances, that occurs at, say, the association's annual meeting. And that's where the actual voting and election occurs. Some people voting in person, some giving their proxies in advance. But in the absence now of in-person membership meetings, certainly for the last few months and probably for the foreseeable few months, if not longer, that's not possible to do. And so, but you still want to have elections, right? Most associations have still gone ahead with their usual election cycles and terms and whatnot, and not suspended those or extended them. But then you go to your bylaws and you say, okay, what's permitted here? And what you'll find, a few kind of key points to point out here. And like I said, this is discussed in much more fulsome way in the article. One is you got to distinguish between kind of four different things. two types of board actions and two types of membership actions. So for board actions, you have board actions that occur during a meeting, in person or teleconference or video conference, or actions that occur outside of a meeting. And then for membership actions, you have membership actions that occur at a meeting, those participating in person or by phone or video, or by proxy, and then actions that occur outside of a meeting. Those are four different constructs that are generally treated differently, each four of those treated differently in the State Nonprofit Corporation Act. And your association is governed by the State Nonprofit Corporation Act of its state of incorporation, not where you're located, but where you're incorporated. Those laws have certain requirements for all four of those things. Like for instance, for board meetings, they say, almost every state says that boards can have a meeting in person or by any other means where everyone can simultaneously hear each other. And that's the same legal effect. For actions outside of a meeting, most states, there's a few exceptions like Texas, but most states say that the only way a board can take action outside of a meeting is by unanimous written consent, effectively meaning all board members vote and they all vote the same way. And most states say that can be electronic. For membership meetings, there's generally more flexibility. Almost all the state statutes say that, almost all say that membership meetings can occur either in person or virtually, audio, video conference, as long as everyone can hear each other. The same quorum and notice requirements and approval requirements apply for virtual meetings as they do for in-person meetings. Most state statutes say that members can vote by proxy, whereas most state statutes say that board members cannot vote by proxy. And then for the fourth one, membership actions outside of a meeting, most, but not all, state statutes say that members can vote by mail or email ballot, and that it's the same approval and quorum requirements as at a meeting, and that can happen by email as well. Now that's most, but not all say that. So for instance, if you're incorporated in New York, as many associations are, the New York Not-for-Profit Corporation Act, believe it or not, does not allow membership meetings to occur virtually. Thankfully, though, for New York nonprofit corporations, associations that are incorporated in New York, Governor Cuomo issued some emergency guidance about 6 weeks ago or 2 months ago that basically overrode that provision of the statute and allows for associations to have membership meetings virtually during the pandemic. These are the kinds of things that you need to look at, because if you have provisions in your bylaws and they are inconsistent with what's prohibited or mandated by the State Nonprofit Corporation Act, those provisions have no force in effect. Your bylaws and your articles of incorporation have to be consistent with the mandates of the State Nonprofit Corporation Act, or they have no legal force in effect. So this is a good opportunity to go back to your bylaws, compare it to your state statute. Usually want to work with legal counsel who is experienced in this area to help you with it, and make sure that you have the maximum flexibility needed to be able to fully and effectively govern your association during this pandemic.
So we are at about 10 minutes after 3. We have about 5 minutes left. I'm going to give you an opportunity to maybe touch on a few items that we haven't touched on. I know there are a lot of questions still unanswered in each of the sections that we've talked about, but I want to give you an opportunity to give sort of some closing remarks of things that people should be on the lookout for moving forward. Sorry, put you on the spot there.
Fine. I'm just trying to make sure I kind of touch on the most important issues. Frankly, I think we have touched on many of the key issues that I wanted to talk about. These are all really complicated, complex issues. There's a lot of financial consequences involved in most of these issues. There's a lot of politics involved in all of these issues. These are not easy things to deal with. In my experience, kind of the associations that are navigating the pandemic most effectively in terms of these legal issues, right? There's lots of other aspects to navigating it effectively that are outside kind of my wheelhouse. But the ones that are navigating these things most effectively are the ones that are informing themselves, educating themselves the most on all of these different considerations, which is very much evolving, right? The first program I did for you guys in ASAE in late February about this stuff, completely different, the advice and guide. I remember that first PowerPoint I put together for that compared to, what I'm speaking about today. it's completely evolved. Even, the article I wrote on meeting cancellations, contract cancellations 2 months ago is very much evolving today. And I see it on the daily advice that my colleague and I are giving to our clients in this regard. You want to try to stay ahead of the curve and to do your education, like participating in online education like this, and reading all the various good articles that are out there, talking to your colleagues. So many association execs are doing great benchmarking, through their online forums with other CEOs or other meeting planners or other legal counsel or whoever your peers are. Because you can learn a lot by what other associations are doing. You also can learn a lot by what's happening on the other side, right? The hotels, the convention centers, the big technology vendors, the web platforms. How are they dealing with these issues? How are they responding to negotiations? Don't be too insular. One of the advantages that we have in our firm is that we work with a couple hundred different associations, so we get to see all these different vantage points. We get to see what strategies are working better with hotels and convention centers. We didn't even talk about event cancellation insurance, but we have a number of clients that actually did have communicable disease coverage before it went away, with no coronavirus exclusion, that we've been working with them to file claims with the insurance carrier to try to recover, and having great success with that. But seeing how the insurance carriers respond and how they respond and in what ways makes it makes your claim much more effective, and you're likely going to have a greater recovery. Same thing when it comes to force majeure terminations. Now we're going to start to see how are the hotels responding when it comes to social distancing requirements and spacing. And you can learn a lot from what others are doing that can make you be much more effective in protecting and advocating for your association.
I think that's a really important point, and what I'm seeing on Collaborate is astounding, and the way that there's a lot of boots on the ground. This is what I'm seeing. What are you seeing? And the peer-to-peer exchanges that organizations and executives are providing to each other is critical. But I do want to take a minute to thank you. The tremendous resource that you provide to the association community, that you've provided today, that you speak in language that non-lawyers can understand, is critical, and very much appreciated. And the ease with which folks can talk to you is tremendous. And we're grateful for you and your expertise that you provide to us. I'm going to formally close this event and let you know that we have a couple of programs coming up. We have one next Tuesday on event protocols and how those are evolving moving forward, and that will be on Tuesday from 2 to 3 o'clock. We also have some programs that are in formation now, one on July 9th that will focus on non-dues revenue during this time, and one on July 16th focusing on component relations and chapter relations and how they're all evolving. So please stay tuned for these programs as well. Thank you again, Jeff, and we will try to make all of these articles and agreements and things available to folks both on our website as well as emailing to participants. So thank you. Have a great weekend, everyone. Stay safe and healthy, and we'll see you again soon.
Thank you, Karen. Thanks, everyone.